I just, backup, always have backup.
So page 3, I think that, these are not numbered for some reason. Cardi-
Yeah, let's say this one should be page
So,
3. This one?
yes. Okay, so this is the new law that's coming in July. So essentially, flippers will have more of a duty to disclose certain things in a transaction. Flippers were getting some pushback in terms of disclosures, and one of the things that we were seeing a lot on PBS and SPQ is, we never lived here type of responses. You guys seen those in flippers? As you guys know, flippers, sometimes they try to cut corners, right? So now, there's going to be additional requirements in addition to the TDS and SPQ. The flippers have to talk about any room additions, structural modifications, other alterations, repairs, a copy of any permits if obtained. So, as you know, the TDS and SPQ have a lot of these categories already in there. What was happening a lot was a flipper would say, well, we didn't get any permits because of, that was it, that category under the TDS where it talks about this, I think it's C4. Has any work been done without permits? Remember that? You guys, all right? And the answer is no, for example. Well, why would they check off no? Well, because we believe you don't need permits for the work that we did. All right? We did work that did not need permits. Or it would ask a question like, what changes or alterations were done to a property, and then it gives us like 3 lines for them to fill in, and sometimes they'll fill in like, they'll just say like complete rehab or something like that, or they'll do something very ambiguous. So this new law is coming in, this new addition to the disclosure requirements is coming in to filter some of that stuff out. Try to increase the burden on the flippers to tell you exactly what's happening with regard to what they've done at properties, okay? So be aware of that, it's coming in July. Any questions on that? All right, yes,
Oh, sorry. Just tell her what page to go to. You're good.
all right. Okay, I know, this is something that probably I've heard from you just before, this is coming into play now. You guys know what ADUs are, right?
Yeah.
So as of January, ADUs can be sold separately in the state of California. Now, it's up to the cities to kind of adopt some qualifications to that. Some ordinances or some ways of getting those ADUs sold separately. I think that in order for this to work, you're gonna have to have title involved, obviously, in that sale of an ADU. But I think you're gonna have to go into a situation where the owner has to essentially become a condominium person, right? Actually develop some sort of a condo plan, a condo ownership plan for the property where the ADU can be sold separately. Because,
Does an ADU have a separate APN number?
no,
There's just one APN.
right? So essentially what we're looking at here is not like a separate property. We're looking at as a unit on the same property being sold separately, which is like a condo.
So how does that affect the title?
That's the issue, right? It's gonna affect title, it's gonna affect lending. I don't know where it's gonna go. I'm just telling you, this is coming in, this is in. And what happens is the legislature will put something out like this that may or may not work. And they'll just throw it out there and see what happens, right? Do you guys remember like a few years ago, the death on transfer deed?
Yeah.
Right? I mean, most title companies fizzled out, right?
Fizzles out.
You know, it was a good idea in concept, hey, we're gonna avoid probate by doing a death on transfer deed, but what title company was honoring that?
No.
No one was. So, I'll just give you the heads up that this is something happening in California. I'm sure some of your sellers will be talking to you about that. Whether a title company will, do anything with that, whether a lender would even lend on an ADU for somebody who's trying to buy an ADU, those are all up in the air, but it is possible, technically. Sometimes common practice is not the same as sometimes law is not the same as reality.
They don't go ahead sometimes.
I mean, I always give this example, right? In order to transfer property in California, you don't need to report anything. People are surprised by that. But transfer of property doesn't one of the elements of transfer of property legally is not recording. Recording just tells the world who owns it. But all it is just, you sign the deed and you deliver the deed and you accept the deed. That's title's transferred, folks. The recording is not a requirement. Title's not a requirement of transferring property. Escrow is not a requirement of transferring property. If I sign a deed and give it to this gentleman, what was your name again? Sorry. Derek? That's right. Derek. So if I sign my deed to my house and hand it to Derek and Derek accepts it, I've transferred my property. Legally, yes, I've done. That's what I've done. Okay? Now, the overlays of title, escrow, recording, all that stuff makes it safer, makes the process trackable, but it's not a legal requirement. Back in the old days, you had no title, you had no mortgages, right? Everything was cash deals, and you bought and sold farms. So, whether this will take off or not, nobody knows. Yes.
How can you transfer, I mean, you can transfer a deed, you can get it recorded, all great, but what does that do for any, obviously, the liens, judgments, or anything for the current owner? It's not getting,
No.
they're still gonna be attached to the property.
Correct.
So whoever buys it, even though you recorded a deed, they'll still have to deal with that kind of stuff if they want to refinance or sell.
Absolutely. Yeah. This is one of the biggest things we see when people buy properties together. They're both on the loan, they're not married. One of the toughest cases I have on properties, partitions, is girlfriends and boyfriends. Or girlfriends and girlfriends, boyfriends and boyfriends. What happens is, there's like the emotion involving like a family law case, but they're not married. So now they're both on the loan, there's a breakup, they don't want to be on title together, one of them's living in there, the other one's not, they don't think it's fair, whatever. So they want to liquidate the property. The question is, and one of them wants to buy the other out, but they don't qualify they don't qualify for a loan. So there's no other option but to sell. Okay? That happens a lot. I had like calls with regard to, people involved romantically buying properties together and not being married, probably a couple times a month. It's an essence, especially if they bought very recently. If they bought a house together 6 months ago, and now they don't get along. Well, the property's appreciated what? A couple $1,000, $10,000? How is it worth it, right? You gotta advise people to stick it out until the property appreciates more. It's nasty situations. So if you're thinking of buying property with your significant other without being married, think about it. I mean, but the reality is I don't see the good side of things, right? Nobody ever calls me up and says, hey, I just had a great transaction with my boyfriend. People only call me when things go wrong, right?
Yeah.
So it's not fair what I'm telling you, like, don't do it, because I only see the nasty side of things. All right.
What page are we on?
Some of the stuff is not, so go to the next highlighted part.
A question before, I'm leaving.
Oh, can you get out? Here's one. Go ahead, sir.
So you were saying, so we don't need title, we don't need to record it and everything, I mean, we just have to, do a deed, sign and everything. So basically,
Yeah.
I can buy a property cash myself, it doesn't matter where the money comes from?
100%.
If I can just buy it for you directly?
100%.
Wow.
But the problem is this, because we live in the world of title insurance, when you go to sell it, if you go to sell it the traditional way, the title company's gonna say, great, we see that you have the deed, but we wanna make sure it's not fraudulent, so we're gonna need some additional steps to go back into the title chain and make sure everything is solid. I'm sure some of you have been in a position where you go to list the property or sell a property, and the title company says, we need an affidavit of deed. How many of you have done that, seen that?
I'm canceling the deal today because of that.
What's an affidavit of deed?
It's like, I couldn't explain it. I'm being truthful.
So basically, if you went and you bought a house cash and you signed a deed and you got it recorded, when you go and you go to sell it through a title company, the title's gonna say, okay, there was a deed recorded, but it wasn't through escrow, it wasn't through a transaction, it wasn't insured. So guess what? Did you threaten that person? Did you hold a gun to their head and tell them, sign over the property? So what title's gonna do, they're gonna request an affidavit of,
From the signer.
from the signer, so you'll have to go back to the person, the original buyer, they will have to sign that affidavit stating that, yes, this deed that I executed was true and correct and, all that. So there will be stuff that if you refinance or sell, you will have to go back to that original owner and they will have to sign or be in communication.
In order to sell it.
In order to sell it.
In order to sell it in a traditional way.
When people die, people get lost, it could be multiple.
Right.
We're like 4 people down that we have to check, so.
And honestly, like, title has a right to be cautious. I had one case in the Keller Williams office in Rancho Cucamonga where the person who was going to sell the property was just a scammer. He wasn't the owner of the property. And he wouldn't come to escrow to do anything. He wouldn't do anything. He wouldn't communicate except through like mail or emails. The agent took the listing, but it was red flags. And he got flagged right after the buyer sent their money in. This is an investor. The buyer's money was tied up in escrow because escrow couldn't release the money until they had mutual agreement. Well, the seller at that point was under investigation by the seller, not the owner, was under investigation by the FBI, so he didn't want to sign any documents. So, and I've heard of situations where people who are in probate or passing away, somebody just signs a deed on their behalf and sells the property. Right? I've heard of 2 this month. So title's very cautious about uninsured deeds. Okay, NHD. So there's going to be some additional categories on NHD. High as well as very high fire hazard severity zones. So this impacts your buyer's ability to be able to get insurance. So you want to get ahead of the game when you're representing a buyer in a area where you're going to have some very risky fire situation because you got to make sure that the buyer can get insurance. You don't want to be right before escrow and then you're told before escrow closing and told that the buyer can't get insurance. So the NHD is going to be expanded. So take a look at it. If you're in a high or a very high fire zone, get ahead of the insurance question for your buyer. At least ask your buyer to look into the insurance right away. Homeowner insurance. Any questions on that? Talked about ADU. All right, let's go. Speaking of ADU, let's go down. Go down a little further. Do that. Okay, so yeah, we talked about that right there. Okay, so it used to be in California that for ADUs, you couldn't rent them out to somebody else, some cities required through an HOA or otherwise that the owners live in the ADUs. If the owners live in the main property with the ADU, those are all done. So essentially, the new law is a permanent prohibition on local government's ability to require owner occupancy on the parcel. So if you can rent out your ADU to separate people, you don't have to rent it to friends and family. You don't have to live in an ADU. It can be separately rented. Okay, so that's a new law that's coming in, and not even HOAs can stop that. Yes.
That was my question. What the HOAs does this new rule override the HOA rules?
Yep, I believe so. I believe it does. There's always a battle between HOAs and the state of California, various things.
Right.
Years ago, it was growing your own marijuana plants. The state says you could, HOA says you can't, the state says no, you can't prohibit that anymore. Building ADUs, that was a battle for a while.
Yeah.
The state says you have to allow them to build ADUs. There's a few other things that there's a constant back and forth with the HOAs in the state of California. But essentially, the state has taken the position that we're going to override HOA requirements to make it easier.
So approval from the HOA is not even needed, or it still would be needed?
So HOAs can have a believe up to 25% restrictions on renting in their association. I think that there's a, I think it's 25%. I think they can have a restriction of no more than 25% of their units being rented out. So that applies here.
Got it.
Okay, so if the HOA's limit is 25%, and you got 25% rented out, they can say no to you. Right? Because they do have, they have the ability to restrict the percentage of renters, and that's 25% in the state of California.
Got it.
Okay. All right, let's go to. All right, we'll go down to a few pages here to landlord tenant security deposits. You should go to the next highlighted section. Okay, so the law is changing with regard to security deposits. Before the new law is coming in, which is in July, at this point, what it was is that you can take 2 months rent for unfurnished, 3 months rent for furnished, right? Now that's changed. Security deposits are limited to 1 month's rent regardless. Okay, so you can only take 1 month's rent for security deposit, starting July. Now, there's an exception. The exception to that is small-time investors. Small-time investors, small landlords are defined as people who don't own more than 2 rental units. If you don't own more than 2 rental units, the old law still applies. But if you own more than 2 rental units, your ability to get security deposits is limited to 1 month's rent. Okay, that's a big change in the law, okay?
I have a question for you.
Yes, they're trying to make it more difficult on investors. Go ahead.
So, I assisted a client with getting into a rental, but they went through, not in my direction, went through hot pads.
Went to what?
Hot pads, which is a property management rental site. So they're in this property, it's a smart home, but it's a dumb home. The AC, the heat comes on and stays on, and it's programmed by the host, which is the owner, and they can't turn it off. And so they contacted the property manager, and they said that's not their problem. There's other problems going on in there that they want the new tenant to pay. How do you handle that?
You want the tenant to pay for what, repairs of the?
Pay for the repairs, so she just paid $400 for someone to come in and dismantle the thermostat so that it would turn off the heat.
Well, my opinion, that's wrong. I mean, even if the lease says something like the tenant's responsible, like a lot of commercial leases will say tenant's responsible for maintenance, for example. However, what is an unwritten rule is that the property's got to be delivered lacking, not having defects, right?
Mm-hmm.
So if the defect existed from before the tenant took place, I think the landlord's responsible.
But how would the tenant have known? They wouldn't have known.
They wouldn't have known. But if they get a contract out there that says, yeah, this has been going on like this forever, I think the tenant has a right to complain about that and probably deduct from the rent to fix it. So I don't think that the tenant should be responsible for that.
And would it be in the tenant's best interest to have a third party come in and look at it?
Yeah,
Okay.
yeah, for sure. With their own contractor out there. The other thing is that, and you reminded me of something. So there is, on the new listing agreement, right, now there is a space on the listing agreement to discuss what smart home functions are coming, are staying or going.
Yeah.
It's something new that's come out, so be aware that that's on the listing agreement. So make sure if the seller says, I wanna take, whatever, the smart AC, whatever it is, or all the Alexa is hooked up or whatever, make sure that information is conveyed to the buyer side, right? In the contract.
Thank you.
All right, go down to the next section. Okay, right there. Okay. All right, so, The Tenant Protection Act is always confusing for people, but essentially the Tenant Protection Act limits, for certain properties, it limits what the landlord can evict people on and how much the landlord can raise rent. The Tenant Protection Act has nothing to do with COVID. It's a pre-COVID law that impacted multi-family dwellings. So anything from duplexes up. It's an exception for duplexes. If it's a duplex where the owner lives in one of them, then it becomes a single-family home. The Tenant Protection Act doesn't apply to that. Single-family homes, Tenant Protection Act does not apply. But if the Tenant Protection Act applies, like apartment complexes, things like that, you have to give a legally allowable reason to evict. Now, non-payment of rent is always an eviction, no matter what it is, right? But if they're paying rent and you want to get them out, you have to give a legally allowable reason. And the reason why this law came into play, a lot of it is, because what was happening is that big company would come out and buy a big apartment complex and then they'd jack up the rents by 500%. So they wanted to stop that. In order for them to stop that, they brought this law into play. Now, the maximum you can actually do on raising the rent is 10% per year. It actually is tied to the consumer price index, but I'm just giving you 10% as an idea. The other thing is that you cannot evict people covered under Tenant Protection Act for any reason. Whereas if I have a single family home and I'm renting the landlord out, I don't have to give a reason for a 60 days notice, for example. But under the TPA, you do, okay? So, they've tightened, not only that, but they've tightened this year, they've tightened those requirements for at-fault evictions. Because what was happening is people were trying to find a way around the law. One of the reasons for evictions would be something like, we're doing a remodel. Was one of the big reasons. And I would get calls from flippers, and they would say, well, we bought this fourplex, we want to kick everybody out. All right, well, what's the reason you kick them out? Oh, we're doing a remodel. Well, what are you doing? Oh, we're replacing windows. That's not good enough. So the law is very specific about what a remodel means. It means the defendant has to be out of there, not able to live there for months, because you're doing a complete remodel. So a lot of stuff's been tightened up in the language in order to stop people from getting around the law. So just be aware that if you're helping a client, buy multi-family housing, you gotta look into the return on investment on that. Because if the people in there are paying way under rent, it could be an issue. You can't just jack up the rents, right?
I knew somebody, she lived in an apartment, and they did give her a 60-day, and I don't remember exactly the verbiage obviously on it. It was because her rent was paid and everything, they said because she was paying under, like, her rent hadn't been raised under market value. So that is a legal reason for them to.
It's not.
Oh, okay.
That's not a legal reason. That's not one of the legal reasons.
Oh, okay.
The most commonly used reasons is complete remodel or taking the property off the rental market, but it's hard to argue off the rental market when you're talking about an apartment complex.
Right.
What about when they have a second unit, like a duplex?
So in a duplex, if the owner lives in one, then it becomes a single-family home. So single-family homes are exempted from this law. So you're okay. The only thing about single-family homes is that a corporation can't own it. So if a corporation owns a single-family home, the law applies. So I always tell people, if you're gonna hold a single-family home in an entity, make it an LLC. Don't make it a corporation.
Okay, so if the back unit, because I have this issue right now, the back unit is occupied, and they already sent a notice, 60 days notice. Do they have to have a reason or other reason than selling?
Do the owners live in one?
Yeah, they live in front.
Okay, no, if the owners live in one, the answer is no, you don't technically have to have a reason.
Okay.
Just make sure that unit in the back is permanent, is it permanent?
It's a permanent.
Okay, good. Because you have a bigger problem if it's not, right?
And it's a low income. It's a low-income renter with a minor.
Where is it located?
It's in LA.
That's a so the city of LA? The city of LA, you gotta talk to LAHD.
Okay,
You gotta talk to the Los Angeles Housing Department.
yeah,
Because anything in the city of LA has to go through LAHD.
okay,
LA evictions are complex,
very.
especially in the city of LA. So, most of the time I tell people pay them to get out.
Yeah, that's why we're negotiating on that.
All right, let's go down to the next highlighted section. All right, right there, yep, listing agreements, this is a change. So listing agreements can't go over 24 months. Anybody taking listings for more than 24 months? All right. Obviously, open-ended listing agreements are not gonna fly, right? You have to have a termination date. But the termination date can be more than 2 years. All right, so, if anybody, I don't think anybody here is doing that, but just so you know, listing agreements are limited. Now, understand something about listings in general, is that there's a lot of times where you see something like, have any of you guys seen anything recorded on title where somebody has a right to list the property? Has anybody seen that? I've seen that a few times. Nobody's seen that? Okay, maybe it's not worth going into, but once in a while, we'll see some company who gave the owner like $100 to record something on their title to be able to list it in the future. And I think part of this new area of law that's coming in is trying to address some of that stuff. So, just so you know, there is a requirement a restriction on listing for over a certain number of days, number of months. Now, the flip side of this is the buyer broker agreement, right, the BRBC. Have you guys heard about that, the BRBC? One of the reasons why CAR put that into play, the BRBC, is to address a lot of these litigation stuff that we had going on back in Missouri with NAR and CAR and the MLS. It used to be the MLS, you could not list in the MLS unless you offered up compensation to the other agent, right? Now you can do a compensation at zero because of the litigation that was going on. So, to address that, what CAR has done is they've developed one document called the BRBC, which is a buyer-broker agreement. It's an agreement with your buyer to help them find a property and get paid a commission. The world is going in that direction. Your industry is going in that direction. Don't be surprised at some point, CAR will tell you have to have a buyer-broker agreement. There's no choice without it. That's going to happen. So get used to the BRBC, get used to your clients signing the BRBC, entering into a contract with you as a buyer's agent. There's going to be obviously a lot of pushback from agents. There is pushback. Every time I bring it up, somebody will say, well, they'll just go next door and have somebody else help them. Fine. But how many times have you guys been out of commission because you try to find a house for somebody and for months, you just go to the listing agent directly. Or they just find somebody else to find them a house, right? How many guys have been there? Yeah. So the BRBC is a way to stop that. The other thing the BRBC tries to do is to stop board arbitrations regarding procuring costs. How many of you guys been in a board arbitration regarding procuring costs? Nobody? All right, you guys know what procuring costs is? Nobody knows? Okay, so I as an agent show the house, show to a potential buyer. Buyer says, thank you very much. They go directly to the listing agent and they get their offer accepted from the listing agent who double ends it. If by the procuring cause of the buyer buying that property could be yes. There's arbitrations at the board that happen because of that scenario. It's good that none of you guys have been involved in that, but that happens. I just had a board arbitration on that issue 2 months ago, where an agent was suing my client for $30,000 because they said, well, I introduced this buyer to this house, essentially. My client won because the person didn't even show the house. But there's like 25 factors that the board looks at for who's procuring costs, closing broker versus original broker. So there's all these factors we look at. So it's good that you guys never been in there, but if you guys ever have to go in there, into that.
I have a question.
Just go ahead.
Is there a statute of limitations on it?
Yeah,
How
it's 6 months after
6 months?
the closing.
Oh.
6 months after closing. All right, let's go to the next section. Oh, right there, yes. Okay, so non-competition. I see these in a lot of team contracts, non-competition stuff and team contracts. I see this a lot in team contracts. The reason I bring it up here is because, in general, non-competition in California is not allowed. So sometimes I'll see a team contract that is very, very, very broad, that says not only can you, like, if you leave us, not only can you not take any of our clients, but you can't even do real estate within like a mile of our, and that's just not allowed, okay? Now, what's still in play is people can't steal your clients. They can't steal your leads. That's still okay, but you cannot restrict people from doing business. So to me, and I'm sure a lot of people who develop those contracts have kind of gotten something off online, right? It is very, very overbroad. That's not going to be enforceable. I think most of the time, team leads don't enforce those provisions, I have seen some brokers try to do it, but in essence, you cannot enforce non-compete clauses in the state of California. Yes?
I've seen that in like a community where they'll have like an in-house agent or something, and then they don't want, other agents coming in, like to prevent you from doing stuff. Is that like, how does that work with that? Or was that a senior community or something like that, and they had like an in-house agent through the
Right.
company and everything?
That's a different scenario a little bit, because what we're talking about here is a contract that's signed by
Oh.
parties. In your scenario, I don't think they can restrict it. They can restrict you from, you're talking about like bringing your client in to see the property?
Yeah, like, the whole process was just like so hard to do just because, they just, if you it was super hard to get a listing in there, and if you can, you could have your signs, you could do this, but the other agent had his stuff everywhere, and,
Yeah, and because of the association, right?
yeah.
Yeah, it shouldn't be allowed, but I guess they can make your life miserable. HOAs, to me, HOAs are more burden than they are helpful. I would never live in an HOA. It's just me. But I've seen so many problems, just small things like you're mentioning, not being able to pull up signs, restrictions about when you can show houses, things like that. So the HOAs can manage their business that way, but they can't discriminate. So if it's a discrimination issue, that's a different level. You know what I'm saying?
Yeah.
All right. Lastly, we'll talk about a couple different things, but we'll go real quick. All right, go up. I want to go to the notary section. Yeah, please. Go down.
it?
Right there.
Oh, sorry.
Sorry, I didn't highlight it, it was my fault. All right, so notarizations can be remote now.
Oh, gee.
The law establishes a framework for licensed California notaries to conduct remote online notarizations. So notarizations can be remote, but there's going to be some safeguards with that, right? It's not going to be just, hey, you show up and whatever. There's going to be some safeguards. You probably have to send your stuff to the notary early, things like that, make sure that you can identify you by face. But essentially, remote notarizations are coming. You don't have to sit in front of a notary anymore to get stuff notarized.
Don't need our fingerprint anymore?
Well, like I said, there's going to be some safeguards, there's going to be fingerprints, but I think all this stuff is going to be handled as part of the remote process. All right, go down to the small claims section, that's highlighted, there we go. Small claims matters have gone up from $10,000 to $12,500 this year, okay? So, a lot of the deposit issues between buyers and sellers are small claims matters, right? $5,000 deposit, seller doesn't want to release it, buyer can take the small claims court. I get really agitated when I see a contract that has like, this is on the old math, for example, I see a deposit that's like $12,000. And I'm like, well, why $12,000? Because essentially what the contract says is that either the buyer and seller have to mediate and arbitrate, or they can go to small claims court, which is an exception to mediation and arbitration. So I always ask agents, why would you make a deposit of $12,000? Essentially what you're doing is you're making your client spend money on mediation and arbitration just to get $2,000 more, right? As opposed to going to small claims court, which is very fast. So my advice to you guys is either make it a substantial amount of money for deposit, or make it less than $12,500, right? I don't want to see deposits of $13,000. Like, literally what you're saying is, the buyer has to make a choice of going to small claims court and disregarding and flushing away $500, or going to mediate on a $13,000 case. So and mediations are expensive, right? Because mediators cost money. So deposits should, be high or low, not close to small claims. All right, let's go down to vacation rentals. Next, there we go. All right, so there's a lot of pushback in the state of California about vacation rentals not providing with all of the different charges, right? People were like, getting Airbnbs for $200 a night, and then on checkout, their cost was $400. So now that's not allowed anymore. Vacation rentals, you have to have full disclosure of all rates, charges, fees, everything up front. Okay? And this starts in July as well. All right, any questions on any of this stuff or anything off topic?
So all this is start on July, right?
I'm sorry?
All this is start on July,
Not all of it. Some of it's already started. So,
the small claims.
well, the small claims, it started already. Small claims is January 1st.
I'm sorry. Uh-oh. How do I get that?
Any other questions on topic, off topic? Anything? You got me as a captain of audience here. Any transactions that are going bad? Right. Well, thank you very much. Thank you for having me.